The opinions expressed on the Custody Queen Show are for informational purposes only and are not a substitute for personal, professional legal advice. The persons discussed are fictional and not based on actual clients.
Thought it was love, had kids in between. You can count on us, we're the Custody Queens. Yeah, you can count on us, we're the Custody Queens.
All right, everyone. Happy Saturday. Welcome back to Custody Queens on Air. I am Sam McBride here with my two favorite blondes, Brittany Van Veen and Kristen Holstrom. Some of you may have remembered or heard our show with Brittany last week. Please feel free and go back and watch it. It was a good show and a lot more to come. We are going to be going through some listener emails, some questions in general, and all things family law. For those of you who don't know Brittany yet, she is a certified family law specialist. She has more than 10 years of experience in the courtroom. She is a dear friend of ours, and we are so excited to have her back. So welcome, Brittany.
And she
Good
is
morning,
a master
everybody.
she is a master litigator, and we're happy to have her. But we want to break into the show, and we want to make this one a little bit more spicy, because sometimes we get a lot of questions, and it's like, are we overreacting? Are we overanalyzing? Or is this just simple? What is right and what is wrong? All right,
So
Sam, let's
Brittany,
go.
yeah, so Brittany, real quick before we get into all of our questions, I have to ask you a question because that's just what I do. If you could spend a day doing anything you want, what would you choose and why?
Anything I want with my kid or without, it's probably a different answer.
That's two different answers. Let's do without. Let's do without.
Let's do without, because there's a lot less of the without. I love to kayak, so that's where I go to like de-stress, relax my brain. I love to ocean kayak, so you'll see me out probably in Laguna Beach, maybe down in La Jolla if I feel like taking a trek down there. I love to kayak. I like to pack a little lunch and go out on the water, eat my lunch out there, and just kind of float around. And then get a really good cup of coffee somewhere after. I'm a huge coffee snob and coffee connoisseur. So any sort of cup of coffee at any point in the day is going to make me happy, but especially post kayaking trip, I love to go get a good coffee.
I love
How about
coffee
you,
all the
Kristen?
time. You know what's sad? Like, if you would have asked me this 10 years ago, I probably would have said, let's start it with a massage. I love the mountains. I love Mammoth, Big Bear. I just love the fresh air. I don't even have to really do much when I'm out there. I just really like. But the first thing that came to my brain when you asked her that question was like sleep, or not even sleep. Do nothing. Do nothing.
At a
Nobody's
hotel with
saying,
room
Mom.
service, Kristen.
And I don't know what that says about me, because anyone who knows me or follows me, I am going 100 miles an hour, like 23 of the 24 hours. And doing nothing sounds pretty darn good. What about you, Sam?
I want to change my answer.
Okay. Go back, Britt. I do love watching a little, what is it, Love After Lockup, and a little, I was watching Prison Wives the other day, and I don't know, again, what that says about me, but I do like watching shows that are interesting.
Yeah, Kristen doesn't like the break from the family law stress of the day. She likes to just add more onto it with reality TV. And I'm a reality TV junkie myself, so I'm not a hater, but it is what it is.
Have either of you watched the reality show? I think it started as a documentary with the girl Natalia Grace.
No.
Okay, so it started with a legit documentary, which I found, fascinating, overwhelming, crazy, almost unreal. Okay, well then,
depending on the day I'm watching it, I have a different theory of who's telling the truth. Like every interview, every documentary I watch, I'm like, no, now I've swapped.
But have you watched now they made like a docu-series, not like a real documentary. Like, I think it's on Lifetime. It's like 8 episodes.
It's the one with the girl from Grey's Anatomy, right?
No, so that was like a remake of the movie. This is actually with Natalie Grace, the foster parents that legally adopt her literally jumping in a car, going with another family and escaping that family. And I'm sitting here going, if this is real life, this is like the most horrific story I've ever heard in my life. But it just kept giving me Dr. Phil, Jerry Springer, like made for TV vibes. And I found it to be absolutely like ridiculous and actually below my desire of wanting to watch it, which is pretty low.
I think the thing with that one is that I can't decide which one I find like more insane. Like it's one of those cases where whatever side you believe is true, whoever you believe is telling the truth versus lying, like neither side of it is a normal situation. Like whatever side is true is, if that is how it played out, is a astounding set of actions that followed. Like
It is
I can't
crazy.
untangle it and I can't look away from
Oh,
it.
Sam,
Yeah.
you got to go watch this. And I found the documentary to be actually like very interesting and very somewhat methodical, and like there was evidence to back up some of these things. And then the show, I don't know, it was on another level. And I think that they all need therapy. That is my conclusion. I think the guardians and the people that actually did a legal guardianship, I do think they were trying to steal her money on every level. I think that there was a lot more going on with her of what is being put out there with Natalia Grace. I don't know. The whole thing is just absolutely crazy.
All right, girls, it's time to get into the emails and questions for the day. So the first one, hi Sam, hi Kristen, hi Brittany. I love your show. My name is Sandra from Burbank. I'm constantly debating with my ex-husband about car seat safety. He won't follow the law, putting the kids in the front seat and using booster seats instead of harnesses. What are my legal rights?
I have had this come up in cases before. It's obviously I am myself am a very anxious car safety in general. So I can always relate to the parents that are concerned in that regard. One of the things that I stress the most, I think can be really important, is education. In one of my cases where there was a concern before, what we did is we agreed that everybody was going to take a car seat safety course, and meet specifically with car seat safety officers that most agencies offer, to get some hands-on like explanation. Here's what the guidelines you should be following are. Here's how to make sure your car seat's properly installed. I think a good baseline is making sure everybody, and I say everybody because one, nobody's perfect. You can always learn better things, better tools. And two, I want to approach it first and foremost from not a finger pointing, but let's all get a little bit of education, a little bit more safety, so we make sure we're all acting in the best interest of our children together. And then it doesn't feel as accusatory, or finger pointing. I think if you take that step and you try to correct it from that perspective, and then it's still an ongoing issue, that's when we get back to a circumstance where we're always looking out for the health, safety, and welfare of the children, being proactive and protective, and it may become something that you have to address with the court, because at the end of the day, everybody wants to make sure your children are safe and protected, and if they're not strapped properly into a car seat, that obviously isn't a safe scenario.
Yeah, I do like your approach where it's not finger pointing. And oftentimes, when you're going in a divorce case, if you call someone out and you say you're not doing this, you could do it better, like people get defensive. But a lot of it really is common sense, guys. Like if your child is on the threshold of being able to be in a booster versus the 5-point car seat, like just talk about it, put it in writing, but again, if it has to go further, take pictures, video record it, like if it really is a legitimate safety concern, and say you have a 3-year-old that is not in a car seat and is thrown in the back seat, obviously that's a legitimate safety concern. But I really hope that most of you are not in a place like this where we have to hire an attorney to talk about a car seat.
I agree with that. All right, our next question's a little quicker. If there is well, maybe not with these ladies.
Nothing is quick with us.
If there is a
that feels like a challenge.
If there is a domestic violence restraining order in place, can the other parent get visitation?
Well, yes. There's the quick answer. I do this with my clients. I'll say I'm going to give you the quick answer, and then we'll talk about it. So yes, they can. Once there's a finding of domestic violence and a restraining order in place, it's going to trigger some presumptions under the law. Presumptions that might be different than the presumptions that would be in place in a case where there's not a restraining order. It's not going to be your end all be all that ends visitation. You're not going to get an end all be all in 99.9% of circumstances. That mean there's not going to be visitation. It may mean that extra protective measures need to be put in place. It may mean there's no visitation at this time. But again, that's at this time. So every case is different. The spectrum of domestic violence in California in the family court is very, very large and all encompassing. We're a very protective and proactive state. There are a lot of different things that can constitute abuse. And the court is going to look at the totality of the circumstances, look at the abuse, and always look out for the health, safety, welfare. I know I keep repeating that, but truly looking out for the health, safety, welfare of the children under those circumstances and determine what makes sense. So sometimes that means we have an overcoming of the presumption very early after that finding of abuse, and the court is going to allow more visitation. Sometimes there are cases that just don't warrant it without a lot of those protective measures being put in place, and it might be a much slower step up. But yes, there can be visitation in place, and what that looks like is really case specific. And that's something you'll want to talk to an attorney about, to call the Custody Queens, talk to us about it, about the specifics of your case, and we can give you our best opinion on what the court's likely to do with that.
And you can give us a call at 1-800-419-7772. That's 1-800-419-7772. All right, this one's for Kristen. Kristen. Hi, Kristen. My ex quit their 6-figure job right before our support hearing to start a band. Can I make a judge make them pay based on their old income?
I think I've actually had a consult with this exact this exact fact pattern. It was many years ago. Yeah, so it is not uncommon for people to quit their job, terminate their job when they know that somebody's going to be filing for a child support or spousal support order. But the court does have the ability to look at a specific period of time, generally 12 to 18 months, and take an average. So if you were making 10 grand a month for 5 years leading up, basically to the point a month before the support hearing, yeah, the court is very likely going to look further into that. Now, if you were laid off or you were terminated, those are going to be completely different fact patterns that the court is going to look at. If you were say you were fired for drinking on the job and you were given 3 notifications and warnings before doing so, then the court has the ability to impute you with the same income. Now, if you worked for Google and they laid off 2,000 employees just because of the economy, then that's a different situation. Are you getting unemployment? Did you get a severance? Are you getting any other additional income? But yes, the court has the absolute ability to impute you at an income that they think is appropriate based on the time period leading up to the support hearing.
And
so no, you are not going to avoid a support order by quitting your job 2 weeks before your court hearing because you think you're super smart.
And just a pro tip, if you're thinking about quitting your job for the purpose of evading support, don't, but also call an attorney, because there's a lot of other factors at play, and there's something called the Discovery Act. And so your personnel file is likely something that's pretty easily obtainable. So you want to make sure that you really know what you're doing before you do it. And that's one of those typical, you shouldn't have done it, you should have called your attorney first. Don't call us after you quit. Do, but we're going to tell you did the wrong thing.
No, because then what happens if you quit your job, which I've never understand this thought process. I'm going to quit my job making really good money that I've been at forever because I don't want to pay him or her X dollars, and I'm going to stick it to them. How are you going to pay your bills? How are you going to pay your mortgage, your rent, your cell phone bill? Like, you're actually just sticking it to yourself, to be honest. And I this is one thing I hear over and over. Well, what if I just didn't have my job when we walked into court? I'm like, well, that would be pretty crappy for you, and the court has the ability to impute you. But I totally missed the band issue when I gave you my first answer. So if you have a passion and you want to do something that is new, and say you're a starving musician for the first couple of years, but you were making a very good and steady income leading up to that, the court does have the ability to impute you at an income based on your experience, your education level, and all of these other factors. So they can't say you can't go quit your job to be in a band, but they can impute you at the same amount of income that you were making at your job, where say you're making 200 grand a year and now you're a starving musician. So you have to walk through all of these issues. And I'm not saying don't go join the band. I'm just saying make sure you know what you're getting yourself into.
I
Two
agree.
words, earning capacity. It's your capacity to
Britt.
earn that the court can then look at. You may not be earning it by your own choices, but the capacity didn't go anywhere. And I'm just going to add in one thing. If you're ever in a circumstance where you think you're going to outsmart the family law court system, you're probably not. You're
They've heard
most
it
of the
all.
time you're not. These judges have anywhere from 10 to 20 cases docketed each morning. You'll see it. They have heard it. They have seen it tried. And they have not liked it when it was tried before, and they're probably not going to like it when you try it now. So talk to an attorney who knows what they're doing, who can guide you to the appropriate and proper way of doing these things. Don't just
Okay, I have one for
don't just
both of
jump
you
in.
to add a little bit onto this scenario, because we've all three dealt with it a million times. We walk into court and I have a letter from my client's employer showing him that overtime is no longer going to be available, even though my client has been earning overtime for the last 3 years very consistently. But now I have a letter, so it must be true.
Well, I think you got a lot of
Well,
potential problems there. I think you start with the hearsay problem initially. And also, the court has the discretion to look back at your income. So it could be that you provide evidence to the court that provides a satisfactory showing to the court that your prospective income is really not going to be what your last 12 months were, for example. And so there are deviations. There's also jobs where maybe you're making money in a specific season and maybe not in other seasons. And so having a fluctuating income is not uncommon, and it's not something that the court can't deal with. The day of the hearing's tough. You obviously haven't explained that to the other side yet. So there's, short of the admissibility issues that I'm hearing and seeing, if your income truly changes and prospectively it's going to change and it's really of no fault to your own, or overtime's no longer available, then the court should be looking at your newer income variable. But that's a big asterisk, because if there's gamesmanship going, or they're looking at amortizing the period of the past 12 months, and there are some peaks and valleys in your income, the court may look at a general approximate number for your income variable available for support. So a big fat depends, right? It's a good point to bring up with your attorney, and you probably want to get that information to your attorney sooner if it's available than the day of the hearing. And I'll let Brittany add on anything to that.
The only thing I would add on is I say this to my clients a lot, so any clients that are listening are probably tongue-in-cheek laughing at me right now. But I think an important thing to remember is that in family law, we're in a court of equity, not a court of law. And most people are familiar with the court of law, with criminal law, a very A plus B equals C formulaic. You did this is the consequence. We're in a court of equity. And so it's what it sounds like. The court is trying to do what's equitable, what's equal, what's fair, what makes sense. That means the court has a lot of discretion in coming to that equitable solution. There is no, that's the fun part about our jobs, is that you can bring, the same exact fact pattern with just tiny little nuance and changes, and the result could be different. And a big part of that is because what is equitable, what's going to be fair in looking at the totality of all of it, looking at all of the circumstances and all of the factors, is going to be different in every single case. And that's why it's important to have an attorney who understands the nuances of the law, knows how to argue all these different aspects of it to get you that equitable result at the end of the day.
Yeah.
And so if you have questions, whether that's because your ex has fluctuating income or potentially hidden income, for example, or you are concerned about your income and the potential support you may be able to get in your case, go ahead and give us a call. We're happy to do a consultation with you, with any of us Custody Queens, at 1-800-419-7772. That's 1-800-419-7772.
And
All
if
right,
you're my
next
client,
question.
hold on. And
Go
if
ahead.
you're my client, I'm telling you, the chances that the court is going to automatically not count any like overtime that you've earned in the time leading up to the court hearing, that is not going to happen most likely. And if you are faking any sort of evidence and your friend, or your neighbor wrote that letter, it's all discoverable. But the court might modify that order going forward after a showing that that overtime is not actually being worked. But if you just don't have overtime the week of your hearing and then you pick it back up, you're going to have a big problem.
It's probably not going
So,
to pass that smell test,
and
and you guys all
that's
know
kind of
that.
what I was getting at with the question
Yeah.
is it is very, very, very common for people, especially when they have county or government jobs, who have had a history of working overtime pretty consistently for 1, 2, 3+ years, that the court is going to count that when they're looking at income. You don't have to work overtime, but if you are, it's going to be considered. But they are very used to people walking into court with the argument that it is no longer available starting today. And you're going to have to make a showing that that actually is happening for a significant period of time. Then you can go back and modify it. But if an attorney's telling you, yeah, we're going to get that to the judge, they're not going to count any overtime, and you know what, it's going to be one and done, you should probably call another attorney.
And not for nothing, I think it brings up a good point that your credibility is so significant in family law, and so pulling a fast one or trying to can have grave and long-lasting consequences. So before you try to trick or perjure yourself, think again. All right,
Okay,
next question.
I want to spice it up a little bit. I love all these questions, but I want to find out from both of you, let's start with Sam. What is one of the most memorable issues that you have ever dealt with in family law over the last decade?
Sure. So there's a lot of memories, as most of you probably know. If you've practiced in family law or you've had a family law case or a friend in family law, there's no shortage of wild stories. I will say for me, I've had the fair share of Jerry Springer opposing parties and things like that. But one of the more interesting cases that I had, and just kind of changing the facts a little bit, just for the purposes of privacy, is dealing or litigating a 7612C case, which is a fancy way of saying a statute changed in the semi-recent past or recent past from the legal realm that allows a court to identify potentially 3 parents if they find that it would be detrimental to only find 2, which is really a very rare set of circumstances where this is applicable, but it does happen, especially in this day and age when there are different ways that you can potentially be a parent. You can be a parent a lot of different ways. Most people know biologically. There's also a presumption if you're married. And then there is something called a 7611D dad in California, which is really when you're holding yourself out as the parent of a child and accepting that child into your house. So for me, that was a really both interesting and passionate case, and we were actually successful in that case. So that was just a good example of how there are exceptions under the law and under the code that you may not be aware exist, and they may be applicable to your case. So if you have any questions about maybe things like that, I would obviously encourage giving us a call so we can run through part of that family code that Kristen, Brittany, and I know a little too well, probably more than we'd like to admit. There is some kind of nuancy stuff in there.
So what that means is you can have more than 2, you can have more than 2 parents, right?
Correct. So yeah, the court can make a finding of parentage in a case for more than 2 parents. It doesn't actually stop saying that it's just 3, but really I've only seen it in very few cases. But it's more than 2 parents if it would cause detriment, which is a slight deviation from what the code normally is, which is looking in general at a best interest standard. Again, this is California family law, so every state is going to have different statutes and applicable rules.
So yeah, and I remember those facts, and I actually remember seeing the joy in your face and all the hard work you put into that and what the result was. Okay, now, Britt, let's get to you. I laugh because Sam is like this absolute passion, and I love that. And I'm thinking in one of my cases, I don't even know that this was mine. I think it was a referral a long time ago, and changing the facts like Sam did. But let's just say that there was an order that somebody couldn't drink because there were allegations of alcoholism, and it was a very, very serious alcohol issue, and someone was trying to portray that didn't exist, and that person was trying to they had to urinate in a test before and after meet like business trips, because that's where a lot of the partying was going on. And let's just say there was a Wizinator used to fake the test. And I'm not gonna lie, that had to be a point in my career. And I remember this was a colleague, and it was actually, someone else's journey. And I just remember thinking, is this why I went to law school? A Wizinator. And it is a real thing. It really is. And it helps people fake a urine test to show that they have not been drinking within a specific period of time. So, Britt, what do you got to top that?
Kristen just mic dropped me. Sorry, guys.
I just love that you're like so heartfelt, and I'm thinking, oh my gosh, I'm going to talk about a Wizinator now.
I'm on the same page as Kristen, though.
That was a bottom for me, and it wasn't even mine, to be honest.
I have a lot of fun stories without going into the specifics of cases, just truly fun stories from remote appearances. Post-COVID, we've now got the ability to appear remotely for cases under certain circumstances, and I have had some fun on what I've seen on remote appearances. So I think the one that really takes the cake, it's my party story that I'll tell people, is that I was doing a remote court appearance once, and someone had a naked man walk onto their camera screen and stay on their camera screen and stand on their camera screen for a good 20 to 30 seconds before anybody
Didn't
realized.
the judge have to say, you need
everybody, it was the quietest I've ever seen multiple attorneys and judges all at the same time. There was a solid silence that befell the virtual hearing room.
That was a crazy time, but I remember you telling me about that.
I walked out of the hearing, out of my office, and had to tell everybody within earshot because I could not believe that had happened. So that's probably my most memorable moment. I don't think I'm gonna.
I know you've had some good issues that either have tugged so deeply on your heartstrings that it made you feel like you unequivocally made the right decision professionally, or like mine, made you really question your profession.
Oh, 100%. I mean, I think by the nature of what we do with family law, we have a lot of those memorable and heartstring moments. I think the emotional aspect of family law is an important one, the empathetic part of it. Like I relate with my clients. I hear the things that they're going through, and I really want to genuinely help them and be in a better place. I had a case, I think we've been a little over a year now, with a client who, it was a move away case. Amazing mom. She was the involved parent. She was the primary parent, the only parent, and she was moving so that she could go to law school. And we still stay in touch this day. We got our move away granted. I still talk to her. I still, get pictures from her and get to hear updates. That's one that sticks with me a lot. I've done a couple. I do contempt litigations, which are filings where people are being accused essentially of not complying with court orders. And I've seen someone who got essentially swindled into signing an agreement, a deal to resolve a contempt before they had an attorney. That was really, I think, no other way to put it than unconstitutional. And we were able to overturn that and help that. And another person I stayed in contact with. A lot of opportunities with what we do to really help people with some of the hardest things that they have to deal with. The funny thing with family law is that people are coming to us at what could be the lowest part of their life, the left turn that no one saw coming, and we kind of help them with all the most important things, with your kids, with the things that matter with you in your life. And I think one of the things that I love about our team is that every attorney on our team is going to make you feel like we care, and not just because we're making you feel that way, but because we all actually do care. And
Sometimes
we
too much.
all, yeah, probably too much
Yeah,
at
sometimes. But
times.
I will say, either one of them, if I'm out, say I'm out of the country with a kid with a soccer tournament, you could call my office and you get either one of them, and they're going to pick up the case just as if I was there. And I'm very, very grateful. And I would do the same for them. And I think that is what makes our team so special. It's not like, okay, you're a number, this is you. Okay, let me read the notes. Like, it genuinely is a team, but we do ride the highs and the lows together. And Sam and I were working on a case a while back, and this was from, the opposing side. And they so badly wanted to recover some medical expenses that they actually faked a sonogram in an attempt to get reimbursement for some medical expenses. And ladies and gentlemen, there is a real website called fakeababy.com. But in conclusion, in a nutshell, like everything else we've talked about, it is real easy to get to the bottom of things. And Brittany is the metadata queen. Brittany
Put on
will
my
get to
FBI
the
hat.
beginning of, like, if I ever have something, I'm like, hey, Britt, is this real? Is this AI? Is this fake? And she does her magic, and she is phenomenal at that. All right, Sam. Any
All right.
last-
Well, I think we're out of time for today, unfortunately. Thank you for coming back again, Brittany. I'm sure we'll have you on a lot more. We're looking forward to it. These are so fun. I love these episodes where we get to really show our listeners what it's like to be in the head and brains of family law attorneys. It's our day-to-day. This is how we talk at the water cooler, if you will. So please join us again next week and every week on Go Country at 8:30 a.m. You can also catch us on streaming. If you want to call for a consult with any of us, please feel free to do so at 1-800-419-7772. That's 1-800-419-7772. And if you have any email questions for us, we love to get those from you. Please feel free to send those our way as well.
And pro tip, don't hire an attorney because you want them to rub your back and make you feel good. It's not worth $600 an hour. You need to hire an attorney that's going to tell you what you need to hear and what you shouldn't do. And we do have attorneys at all hourly rates. And remember,
Let love rule.